Hey everybody, I hope you've been doing well. Today, as promised, we're going to talk about that Weeks v. United States case that I mentioned earlier. If you didn't get a chance to see the Olmstead case, where you will actually see this case applied, I'm going to go ahead and I'm going to drop a little card for you here. I do recommend, after watching this, you go watch that one, not just because it's an extra view for me, but because it actually is interesting to see the way the court applies this later. So, as usual, if you like what I put out on this channel, do me a big favor and hit that subscribe button. If you like this video in particular, there's the like button. Give it a little tickle till he turns blue. And there's also that bell icon, which, as you can see, I haven't made a little GIF for yet. Go ahead and hit that and they'll give you notifications when I actually do post the videos. It all really does help the channel and I always appreciate it. Also, and welcome, as we've had a couple extra subscribers since the last time I posted. It's lovely to have you and I hope that you're doing well. So let's go ahead and take a look at what on earth happened to Fremont Weeks. He, on December 21st of 1911, found himself arrested by a police officer in Kansas City, Missouri at Union Station. Now, the charge that he was arrested for was using the mail to transport games of chance, specifically lottery tickets. Now, when he was arrested, the cop didn't have a warrant to do it. After his arrest, the police sent other officers to Fremont Weeks' house. And a neighbor in the area pointed them to where he kept a spare key, because why wouldn't they? And the officers then entered Weeks' house and started tossing the place, looking for anything and everything they could find related to that lottery mailing charge. They went through his papers, his drawers, his cabinets, everything. They ended up finding a stack of papers and other effects that were generally incriminating toward the lottery charge. They took all that stuff. Again, no warrant to enter the house, no warrant to search the house, no warrant to take anything. And they gave all of that evidence to the U.S. Marshals. They then went back to the house, this time with the marshals in tow, and someone in the home let them into his room again. And at that point, they found more stuff, more papers, more lottery tickets, more other effects of an inculpatory nature. But what they didn't have and what they didn't find was a warrant to conduct that search too. So far, 0 warrants, none, bupkis. When it all came out that the police had searched and taken his property, Weeks actually did exactly what he was supposed to do, and he was timely about it. He filed a request for a return of his property, and the government said no and refused to give him back his stuff. The trial court at the time heard the arguments where he made a Fourth and a Fifth Amendment claim. Again, the illegal search and seizure and the incriminating evidence, the incriminating statements discussion that we've had before. And at that point, the trial court said, sure, we're going to compel the government to give you back some of this stuff, but if it relates to the charge you're being held on, tough look for you, the government gets to keep it, and that's where Weeks ended up. So on appeal, the Supreme Court took a look at this, and as usual, they had a question posed to them. And as they phrased it, it was in effect whether or not the government got to use evidence that was illicitly gained at trial. That's the basic question. So they went and looked at case law, specifically the case law related to the Fourth Amendment, trying to figure out why we had it, what the purpose of it was, and how it should apply in this case. And the court's view was that the Fourth Amendment was put into the Constitution to limit the power of the government and to restrain it in that exercise of power. That's its whole purpose. It's to put a hard and fast stop on government action. The court went far enough to say that the Fourth Amendment protection reaches all alike, whether accused of a crime or not, and the duty of giving to it force and effect is obligatory upon all entrusted under our federal system with the enforcement of the law. In short, your Fourth Amendment is in place whether you've been accused or not, and it's the government's job, through its enforcement agents, to respect and protect that amendment. And as I mentioned in the Olmsted video, which I cited to for you before, the court had gone through a fairly lengthy analysis of the Fourth Amendment cases prior to this. And in that review, they noted that the court made no real distinction previously in admissibility between illegally gotten and legally gotten evidence. The only real recourse a citizen had was a legal suit for monetary damages. If the cops could get it in front of the court would allow it to be used. However, in the Weeks case, the court said that was no longer going to be acceptable. In effect, that if you had an individual who in the performance of their duties violated the Constitution in that performance, they should find no sanction in the judgments of the court, which are charged at all times with the support of the Constitution. In effect, you don't get to wash your dirty laundry in my courtroom. And if the courts continued to sanction that improper behavior, they were, in effect, stripping the Fourth Amendment of all of its meaning. What's the point of having a constitutionally protected right if the police can violate it and the courts just let them use the evidence anyway? And so the court then applied this basic concept to Weeks's case, and what they ended up saying was the police had no warrant to enter the home, they had no warrant to search the home, they had no warrant to take his property, all of which he had a right to protect himself against. And in doing so, they violated his Fourth Amendment right. And in allowing the evidence to be brought into trial against him, the lower court erred and they reversed the decision. This action is something called the exclusionary rule, which I also mentioned previously in Olmsted. Now, one thing to also keep in mind about this rule in this case is only applying to federal courts, not state courts. That's because of the dual sovereign issue and a lack of something called incorporation, which we'll get to in another case, which is Maps v. Ohio. So that's the Weeks case. And the use of the exclusionary rule in a shift of the Fourth Amendment's previous application to evidence illegally seized by the government to be used against a citizen at court. I hope you enjoyed it, as always, and do reach out and comment below. I enjoy chatting with you guys and would love to know what you think about the court's analysis. And until we have a chance to meet again, I hope everyone is well.